Good afternoon. Thank you for joining us today. For those I haven't previously met, my name's Sue Apps. I'm a partner in the Employment, HR and Business Immigration team here at Ashfords, and I'm joined today by my colleague Emily Bowden, an associate solicitor in the team. This is the first in what we intend to be a new series of regular webinars, which the team will be presenting. We're hoping the next one will be around September, October time, with a topic to be confirmed. So we're recording this session. It's going to be sent to everyone who's registered after we finish, but it will also be available on our website. So if you have colleagues or contacts who you think might be interested in watching, do direct them that way. In terms of the agenda today, Emily's going to start us off with a quick update on some recent legal developments and housekeeping that you may want to be considering. I'll then be covering the Court of Appeal case of Higgs and Farmor's School, which looked at discrimination claims in the context of the manifestation of an employee's belief. We then added another case update to the published agenda. I'm sure you've all heard about the recent Supreme Court case regarding the definition of gender for the purposes of the Equality Act, and we didn't feel that we could ignore that hugely important case. So finally, Emily will bring the whistle-stop tour home with a quick update on where we are with the Employment Rights Bill. Our intention had been to have a Q&A at the end, but because of the addition of the Supreme Court case, which isn't necessarily a quick case to cover, we're not going to do that, but please do reach out to us directly if you have any questions on anything we cover today or anything else. So with no further ado, I will pass you over to Emily.
Thanks, Sue. So I'm going to start with an update which is not necessarily new because it came into effect from the 26th of October 2024. But we thought that seeing as employers do seek to carry out policy review processes at this time of year, that would be sensible to include it. So as you may recall, this amendment to the Equality Act introduced a duty on employers to take reasonable steps to prevent sexual harassment in the workplace. This means that employers are now legally required to actively prevent, address and resolve sexual harassment of their workers, including by third parties. Previously, there had been no proactive legal obligation to do so. Weight has been added to this duty through the tribunal process, in that any compensation awarded for a successful claim can be subject to a 25% uplift should an employer fail to comply with its preventative duty. The Equality and Human Rights Commission can also take action where there is evidence of organisational failings to prevent action, even if no incident of sexual harassment has actually taken place or been found to have occurred. So, what can employers do to comply with their preventative duty? Well, proactive methods would include things like developing and or updating relevant policies. Now, most people have an anti-harassment policy, but you could go a step further by introducing a standalone sexual harassment policy. The policy should clearly define sexual harassment, provide examples of unacceptable behaviour, and set out the consequences for any breaches. It would also be important to specify how harassment can be reported with reassurance that this will be on a confidential basis and without fear of retaliation. It would be advisable to have multiple means of reporting, such as by email, telephone, or maybe even an online portal. This will make sure that it is very accessible. It will also be important to foster a safe reporting culture to make sure that staff feel they can report harassment they experience themselves or that they witness, knowing that there will be no fallout from that reporting and that their concerns will be taken seriously. This can happen through mandatory in-work training so that employees at all levels understand what is considered sexual harassment, how it can be prevented, and how it can be reported. One-off training, however, is unlikely to be considered sufficient, so it would be important that refresher sessions are conducted on a regular basis. You could also look to undertake a risk assessment to identify potential situations which would give rise to sexual harassment and take steps to mitigate those risks. You can also look to take reasonable action against alleged perpetrator. This would include acting promptly to investigate complaints fairly and thoroughly, and if harassment is found, take appropriate disciplinary action. Employers could also look to offer support to those who report harassment, such as access to counselling services, or if there's a need, to offer mediation to help navigate workplace dynamics. So the current updates that have come into force this month in April, as is standard at this time of year, statutory rates and limits in respect of pay awards have been updated, which are summarised on the next slide. There we go. Employers will need to make sure that they are using the updated rates for relevant calculations moving forward. These may be in respect of salary, redundancy payments, or potential employment tribunal awards. In addition to the updated rates, there is also new provisions coming into force under the Neonatal Care Leave and Pay Act 2023. These came into effect from the 6th of April 2025. Eligible parents can now take up to 12 weeks of paid leave if their baby requires neonatal care. This is a day one right, which applies in respect of babies who are admitted for neonatal care within 28 days after their birth, for which care lasts at least 7 consecutive days. This entitlement is in addition to any right to other family leave, such as maternity, paternity, adoption, or shared parental leave. And employers should familiarise themselves with these new rights and how they work in practice. They should also look to update their existing family leave policies to include provisions relating to this new right. Next, in terms of horizon scanning, alongside the various updates that are expected in the next 18 months as a result of the Employment Rights Bill, which I'll be looking to cover later in this webinar, it's expected that the rights provided for under the Paternity Leave Bereavement Act 2024 will be introduced in the near future. This act was given royal assent in May 2024 and will grant fathers and non-birthing parents leave if their partner dies within the first year after the birth or adoption. This leave will be a day one right, and it is anticipated that it will increase the period of leave which the non-birthing partner would be entitled. Early indications have suggested this would be around 52 weeks, but is yet to be confirmed. At this time, it's important to note that the Act only gives access to leave rather than pay. Further detail on pay is likely to be provided once regulations intended to implement the Act have been presented and approved. Over to Sue for some important case updates.
Okay, thank you, Emily. Yeah, there have been two really important cases in the senior courts this year, both tackling issues that are going to become more and more prevalent, employers are going to be grappling with a lot more in the future. So we wanted to provide brief updates on these decisions and what they mean for you as employers. So the first is the long-awaited Court of Appeal decision in the case of Higgs and Farmor's School, which provides guidance on how the law on discrimination treats the expression of a belief. So let's look at the background to this case. We've got the claimant, Mrs. Higgs, who was a pastoral administrator and work experience manager at Farmor's School. Now, Higgs shared posts on social media that mentioned brainwashing children and stated that the government's stance on the teaching of relationships and sex education in schools meant that children will be taught that all relationships are equally valid and normal, and that gender is a matter of choice, not biology. A parent flagged these posts to the head teacher of the school, complaining that they expressed homophobic and prejudiced views. So the school investigated the posts under a disciplinary process, and Mrs. Higgs was dismissed for gross misconduct due to a risk of reputational damage to the school. She raised complaints in the Employment Tribunal of direct discrimination and harassment on the grounds of a number of beliefs, including a lack of belief that a person can change their biological sex and a lack of belief in same-sex marriage, which shows the ET decision. The claims were initially dismissed at Bristol Employment Tribunal, with the tribunal finding that although the claimant did not in fact hold homophobic and transphobic views, the school had concluded that the language of her posts might reasonably lead readers of them to think that she did, and those views would be unprotected and unacceptable, and that was the reason why it had dismissed her. So there was an appeal to the EAT and a further appeal to the Court of Appeal. And what did they decide? Well, the Court of Appeal concluded that the decision to dismiss Mrs. Higgs was discriminatory because of her beliefs. The court was prepared to assume that the school was entitled to take objection to the post, that the language was gratuitously offensive and it was relevant to the claimant's work. But nevertheless, the Court of Appeal concluded that the dismissal was unquestionably a disproportionate response. And it gave some of the reasons why it felt that the decision was disproportionate. It says the language was not grossly offensive in the circumstances and didn't appear to be intended to incite hatred for gay or trans people. It was considered relevant that some of the comments were stupidly rhetorical exaggeration, that's the words they use, and were therefore not likely to be taken literally. The language was not the claimant's own. Some of her posts were reposts of social media from the United States. And she did say that she didn't agree with all of the language used. Crucially, there was no evidence that the reputation of the school had been damaged. The court found that the risk of widespread circulation was speculative at best. There was no suggestion that readers of the posts would believe they represented the school's own views. The claimant had posted them from a personal account with her maiden name, and only one parent had recognised her. The Court of Appeal also accepted that Mrs. Higgs would not have let her views influence her work. She'd never displayed discriminatory attitudes to pupils or expressed her views in the workplace. And in the whole 6 years she'd worked at the respondent, there'd been no complaints about her work. So it's clear that the forum and the context for what was said was relevant, as well as the content and the manner. And the Court of Appeal noted that something that might be unproblematic on a private Facebook page could justify different treatment if communicated in a work setting. So the outcome of the case is fact-specific, but the principles are wide-reaching. Now, the Court of Appeal's focus here was on proportionality. Did the decision to dismiss go too far? Well, the court certainly confirmed that the school was entitled to carry out an investigation of some kind in response to the complaint. And indeed, I'm sure you'll all agree that it would have been irresponsible not to. But the conclusion reached was that in the context and the circumstances of this case, dismissal was simply disproportionate. So, next slide, please, Fran. Why is this considered a landmark case? Well, it's because of its impact on direct discrimination law. The general approach to direct discrimination is it can't be justified. If you treat someone less favourably because of their protected characteristic, that is simply unlawful. However, if in its defence the employer argues its allegedly less favourable treatment of an employee is not because the employee holds a protected belief, but it's because of how the employee has expressed the belief, the tribunal will then need to decide, number one, whether the alleged conduct was a manifestation of belief, two, whether that manifestation itself was objectionable, and then three, whether the employer's response was objectively justifiable. So it's still the case that dismissing someone because of their religion or protected belief is unlawful. However, dismissing an employee because of something objectionable about how the belief was expressed is potentially justified and lawful if the employer can show that it was a proportionate response to the objectionable feature. And that means that religion and belief cases require a different approach to other protected characteristics. So, tips for employers when considering matters relating to religious or philosophical beliefs? Well, conduct a fair and nuanced investigation. Ensure that any disciplinary investigation into an employee's expression of beliefs focuses on the manner and context of the expression, not simply the fact that a belief was expressed. Avoid jumping to conclusions based on public reaction or reputational concerns alone. Disciplinary decisions must not be based solely on vague or unsubstantiated concerns about reputational damage. You need to consider whether there's actual evidence that reputation has been damaged or will be damaged. Ensure that decision makers in a disciplinary process are genuinely impartial. So in this case, the court noted the importance of not predetermining that a protected belief is unacceptable simply because it has provoked complaints. And as we always say, document how decisions were made. including how competing rights and proportionality were assessed. And that's going to be essential in defending any claim and showing that you took a balanced and lawful approach. And we'll look at some factors that may make disciplinary action more likely to be objectively justified. And that includes if the objectionable comment or behaviour occurred in the workplace rather than in a personal or private capacity, such as on personal social media. If there's clear evidence or a heightened risk of reputational harm to the employer rather than mere speculation. Did the views expressed pose a genuine risk of influencing the employee's conduct at work or their interactions with colleagues, service users, or others? Has there been evidence that the employee has previously demonstrated behaviour that raises concerns? So, for example, towards colleagues from minority or vulnerable groups. And lastly, did the employee show any insight into the potential impact of their actions? For example, have they refused to remove or reflect on posts that are known to have caused offence? That might lead to concerns about their ability or willingness to prevent future inappropriate conduct. Now, the Court of Appeal warned employers against relying too heavily on the last point. They stressed that whilst it was understandable that an employer would want to have confidence that the employee appreciates and acknowledges what they did wrong to avoid repeated behaviour, they said if the case is not one that would otherwise justify dismissal, it's hard that it should be marked up in seriousness because of a failure to make an acknowledgement of fault which the employee would genuinely find difficult. So, in conclusion, employers shouldn't be looking at this case and thinking it gives employees carte blanche to express offensive views. No, employers are still required to take action to prevent harassment in the workplace. Employers should still be emphasising an inclusive workplace and the need for respect and appropriate behaviour in the workplace. But there will be a need for caution in taking disciplinary action in relation to personal views expressed by employees in purely personal forums. It doesn't mean you never can take action, but context is going to be important and a proportionate response will be required. Okay, next case is the For Women Scotland case. This is the Supreme Court case. So if we look at the background to this one, we have an application for judicial review made by the feminist voluntary organisation For Women Scotland. Now, the group were challenging guidance to legislation which set out an objective for public boards to have a 50% representation by women. The statutory guidance related to that legislation stated that where a full gender recognition certificate has been issued to a person, that person's sex is their acquired gender. And For Women Scotland sought a declaration that this guidance was unlawful. So the central question on the appeal to the Supreme Court was whether references in the Equality Act 2010 to a person's sex and to women and to men are to include persons who have acquired gender through the possession of a gender recognition certificate. Now, the focus of the appeal notably was not on the status of the large majority of trans people who don't possess a full GRC. Their sex at law has always been their biological sex. So the Supreme Court unanimously held that the terms man, woman and sex in the Equality Act refer to biological sex. They felt that interpreting sex as certificated sex would cut across the definitions of man and woman, and thus the protected characteristic of sex in an incoherent way. There were also concerns that a certificated sex interpretation would create two subgroups within those who share the protected characteristic of gender reassignment, giving trans people who possess a gender recognition certificate greater rights than those who do not. Employers and service providers who are seeking to perform their obligations under the Equality Act would have no obvious means of distinguishing between those two subgroups, particularly since they can't ask whether someone has got a GLC, as that information is private. But the court did emphasise that this decision does not reduce trans people's protections from discrimination, whether or not they have a gender recognition certificate. The Equality Act expressly prohibits discrimination and harassment against trans people. And it's not necessary to have a gender recognition certificate in order to be protected. It's also worth noting a trans person may also be protected from direct sex discrimination and harassment because this applies to perceived sex as well as biological sex. So, for example, a trans woman who is refused a job because she's perceived to be female would still have a direct sex discrimination claim. So what does this mean? Well, put simply, it means that under the Equality Act, a woman is a biological woman or girl, i.e. a person born female, and a man is a biological man or boy, a person born male. If someone identifies as trans, they don't change sex for the purposes of the Act, even if they have a gender recognition certificate. So even if a person has got a gender recognition certificate, had their birth certificate, passport, marriage certificate changed to their acquired gender, they won't be recognised as that sex under the Equality Act. So this is where it gets tricky. Some, including the government, initially thought this provided us with clarity. But what we're actually left with is a wholly unsatisfactory state of confusion about the practical implications of this decision. The Equality and Human Rights Commission have been scrambling around to update their guidance in light of the decision. And to their credit, and for what it's worth, interim guidance has been provided very quickly and has attempted to address a key question in relation to toilets and changing facilities. This is a really wide-reaching topic which would take hours to cover, so we're just going to focus on that guidance for now. If we could move on, please, Fran. So the interim update makes it clear that where a single-sex facility is provided, an employer should not allow trans people to use the facility aligned to the sex with which they identify. So trans women should not be permitted to use female toilets. Trans men shouldn't use men's toilets. But that doesn't address how to balance the provision of single-sex facilities against the rights of trans people not to experience gender reassignment discrimination and harassment, in particular where there are no suitable or equivalent facilities for them. And this means that as things stand, there are risks of sex discrimination claims if employers don't follow the EHRC guidance, but we've got no practical answers as to how to mitigate the risks of gender reassignment discrimination claims associated with moving away from more inclusive provision. So the interim guidance suggests that the provision of mixed-sex toilets, washing or changing facilities will address this challenge. But whilst that might be a longer-term solution, it doesn't address all of the practical challenges faced by employers in the short term. One potential practical issue that's been raised is regarding the potential for inadvertently outing individuals. For example, you might have a trans woman in the workplace who is not known by colleagues to be trans and has been using the female facilities for years without any complaints or questions. And now suddenly she's expected to, or required to use the men's facilities. And it's hard to imagine that the EHRC intends that an employer should be required to essentially out a trans employee, which would of itself carry discrimination risk. In terms of policing, will employers always know if an employee is trans? And in real terms, are employers going to have any desire to police such a policy? So what practical steps can employers be taking? Well, the most likely solution appears to be identifying suitable third spaces. So it's sensible for employers to audit their current facilities to understand what mixed-sex facilities they already have and whether any additional facilities could or should be redesignated as mixed-sex spaces. In relation to toilets, a simple redesignation of most existing single-sex toilets, as for example unisex or inclusive, would be unlikely to meet the health and safety executive conditions for mixed-sex toilets if they're cubicles rather than individual lockable rooms. So it's not going to be an easy solution. However, as the redesignation of existing spaces might be the most practical, immediate way of creating mixed-sex space in the short term, employers may need to work with their building consultants and landlords to find the right balance of facilities for their premises and workforce. Look, while it's clear that the watchdog did what they could to pull together guidance for employers following the Supreme Court decision, and at very short notice, it has come under criticism and it's left us with significant questions on practicalities and indeed legal risks going forward. The EHRC has confirmed that it's working on updated statutory and non-statutory guidance and that its aim is to provide an updated code of practice to the government by the end of June for ministerial approval. So in the meantime, if there's an easy solution with regards to redesignating facilities as mixed sex, consider doing it now. But if not, I'm going to put myself out on a limb here a little bit, but the general balance of risks means that I would be inclined to hold tight for now until more substantive guidance comes through. Take legal advice on balancing specific risks if a particular issue arises. So that's that case, not without its issues. We're going to move on now for Emily to provide an update on where we currently are with the Employment Rights Bill.
Thanks, Sue. So as we are all likely aware, the plan to make work pay was a key aspect of Labour's election campaign, which resulted in the introduction of the Employment Rights Bill in Parliament on the 10th of October 2024. This has been hailed as the biggest update to rights at work for a generation and has been the subject of a lot of commentary since its introduction. With this in mind, and given the time we have in this webinar, I do not intend to go into depth about what the bill is seeking to do, and instead just to provide some practical considerations in relation to the key likely provisions which you could start seeking to implement now. So at the date of this webinar, the bill remains at the committee stage. This involves the members of the House of Lords conducting a thorough line-by-line examination of each of the individual parts of the bill to consider whether changes are needed to wording or whether further clauses are required to properly deal with issues. So far, the committee stage has 3 days listed. One was last week on the 29th of April, one this Thursday on the 8th of May, and the following Thursday on the 13th of May. It is unclear whether further days may be needed given the extent of the bill. At this time, there are no firm dates as to when the various provisions proposed within the bill might come into force. Some will likely require very little additional regulation to come into force and therefore may be introduced as early as October 2025, whilst other more complicated aspects which require further regulations with associated consultation before they can be brought into effect may not be implemented until October next year. So in terms of practical considerations, I've plucked out a few of the key likely provisions and just provided some commentary on what you could be seeking to do now. So in relation to the day one right for unfair dismissal protection, subject to a statutory probationary period, this provision is anticipated to be one of the last to be implemented because it will require substantive consultation. It's too soon to be seeking to amend employment contracts to include reference to something akin to a provisional statutory probationary period. However, we do appreciate that often little to no process is followed when dismissing someone with less than 2 years service where there are no other clear risk factors identified. So in order to move towards a statutory probationary period, we would suggest that it would be a good time to get used to going through a formal process in circumstances where dismissal might arise prior to 2 years. This does not need to be under a formal process, but can be similar to one already used by the employer when undertaking a dismissal by way of conduct, capability, or performance, albeit it can be in a much more condensed format. Similarly, now would be a good time for employers to undertake an audit of their workforce to identify any individuals with less than 2 years service who they have concerns about. This may be for performance, capability, or conduct, and you could start to deal with them through some form of process. we would recommend that all steps taken and any outcomes should be recorded on their personnel file so that they can be relied upon in future if needed, whether that be once they hit the 2-year threshold or whether the day one right comes in before that time. In respect of the increased fire and rehire protections, the bill intends to make it automatically unfair to dismiss employees solely to rehire them on amended terms, save where there are exceptional circumstances relating to financial hardship. The strict approach proposed will make it significantly harder to make changes to terms and conditions without the workforce support. Therefore, if you're aware that something needs to be changed and it's unlikely to be readily accepted, it would be prudent to start the change process sooner rather than later. While the practice of fire and rehire now is not without risk, therefore we'd say get some advice before doing it, it would certainly be easier to do it now than once the relevant provisions in the bill come into effect. It may also be a good time to consider the scope for expanding the use of flexibility clauses within your template employment contracts to provide the contractual right to unilaterally make changes, such as to benefits packages or times at which employees work. However, these would need to still be exercised reasonably. Now, I touched upon earlier amendments to sexual harassment to increase protections, which came into force in October. And the Employment Rights Bill intends to enhance these obligations further to include all reasonable steps to prevent sexual harassment. And it will also classify sexual harassment disclosures as protected disclosures, qualifying for protection under whistleblowing legislation. Given the absolute nature of this obligation and the added protective right, it would be prudent for you to make sure that you have clear and well-established practices in place now, so any gaps or issues can be ironed out promptly. Flexible working rights will also be bolstered, as employers will only be able to refuse flexible working requests on reasonable grounds, with a requirement to provide clear explanations for any refusals, as well as why that refusal is considered reasonable. This is particularly relevant at the moment, as we are experiencing an increase in requests for advice around returning employees to the office following periods of home or hybrid working. Whilst there is no law strictly prohibiting such a change, the proposals in the bill will mean that flexibility is the default position. We appreciate that HR teams are normally bound by the intentions of senior managers, and therefore now would be a good opportunity to start to try to get the culture and tone right internally. This will involve challenging approaches that do not permit for flexibility to identify if the reasoning for that approach can be objectively justified, and instilling that blanket approaches should be avoided. In relation to 0 hours contracts, these will be reformed through implementing a right to be offered a contract reflecting regular working hours, as well as the need to provide reasonable shift notice and pay compensation for last-minute shift cancellations. With that in mind, now would be a good time to audit your workforce to identify those currently engaged on a 0 hours basis and whether in reality that affects their working arrangement. If it doesn't, it would be a good time to consider what contract might accurately reflect the hours they work and the impact that this could have on budgeting moving forward if their contract needs to be changed to align with what happens in practice. In doing so, it may also be sensible to identify any fluctuations in demand for workers, to identify where fixed-term contracts may be more appropriate, and review current systems for managing shifts and shift changes so that reasonable notice practices can be considered. We appreciate this may involve implementing more sophisticated or efficient systems to manage shifts ahead of the reforms. We suspect that taking these early action points should help with the transitional work required as the bill progresses towards implementation. We also anticipate that future developments in respect to the progression of the bill and the consultation outcomes will feature in future events which we host. So please do watch this space.
Thank you, Emily. I think we can all agree that what with the Employment Rights Bill coming through and the cases that we've just covered, the next few years are likely to be pretty interesting and challenging for anyone working in employment law or HR. So let's stick together and we'll get through it. But that brings us to the end of our presentation. As suspected, the last minute add-in of the Supreme Court case didn't really leave us time for a Q&A, but please do reach out to us if there anything arose from today's presentation that you wanted a little bit of clarity on. Please just drop us an email and we'll try and get back to you on that. Thank you for joining us today, and we very much look forward to seeing you at the next one. Have a lovely afternoon.